Good morning, everyone. It's Carol Williams with Williams Immigration, and we are back for another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. So, I like to dive right in. The first thing I want to talk to you all about is increased biometrics. There was a published rule. It is a proposed rule, so it's still in the proposal phase right now, to increase the individuals who are required to provide biometrics during an immigration case with USCIS. So essentially all applicants and quote individuals associated with immigration benefits would be required to submit biometrics. So biometrics, just so that we're all sort of working with the same information, in this proposed rule would be fingerprints, DNA, facial, and iris scans. Currently, biometrics is, for some cases, fingerprints, photographs, and in some family-related cases, DNA testing as well. The applicants, that's pretty self-explanatory. That's the person that would be the beneficiary of the recipient, I should say, the recipient of the immigration benefit. So that would be, the person that's coming in on the non-immigrant visa, the employee, the person who will be the beneficiary of the green card, that's the person who is your applicant. Now, individuals associated with the application widens the scope of the people that would be required under this proposed rule to provide fingerprints, photographs, DNA, facial, and iris scans. So individuals associated with an application could be the petitioner, the sponsor, family members that are included in the application, and all of these folks would include U.S. citizens and current lawful permanent residents and minors. So that is a big shift in who would be required to submit biometric data to the Immigration Service. Public comments on this proposed rule, and again, this rule is proposed, but public comments on this proposed rule are due by January 2nd of next year, 2026. So if you've got thoughts on this proposed rule and you would like the government to know what your thoughts are and take them into consideration as they look at converting this rule from a temporary proposed rule to a permanent rule, let them know your thoughts and send in your comments. Public comments are due by January 2nd, 2026. The next thing is the public charge. So public charge essentially is a mechanism for USCIS to determine whether or not green card holders will apply for, receive, and use public benefits. That is essentially what public charge means. The Immigration Service wants to make sure that if you're coming here as a green card holder / lawful permanent resident, that you have the finances to do so. So we use the phrase public charge. It's been reported that there has been new guidance provided to officers when they are evaluating public charge. And so these evaluations are now based on medical conditions. And so officers have been instructed that they can deny applicants for lawful permanent residence / green cards if they have the following if they have certain medical conditions, which include at this point diabetes, obesity, cardiovascular medical issues, and or mental health issues. The reason behind this, they've wrapped it into the public charge analysis, essentially making the immigration officer consider the projected costs for that individual to manage certain diseases. Without, the key for the USCIS is without government assistance, without applying for and receiving government assistance. So there have been some initial thoughts thrown out there around this. This hasn't really gotten a whole lot of sort of press yet, but some initial thoughts thrown out there about this new analysis or this additional analysis when looking at public charge is that it really gives an individual officer much more discretion when looking at someone's medical information. There's no, as of right now that I'm aware of, there's no clear guidance on how an officer is supposed to determine whether or not an individual person's medical situation will, what the cost of that will be long term. Because after all, these officers they're not medically trained. So kind of see where that goes. And it really forces the officers to make a whole lot of assumptions about medical care that's needed. Are they going to say that anybody that has heart disease are they going to assign a fixed number? So there have been thoughts out there that this is really sort of a cookie cutter analysis at this point. And this guidance seems to go against what's currently in the Foreign Affairs Manual, which says that officers can't deny applications based on sort of these what if or we think these will happen scenarios. Because after all, somebody that has any of these medical conditions, diabetes, obesity, cardiovascular issues, and mental health issues, can control them, and it frankly may not cost a whole lot for them to control. So I think there will be more discussion on this as we move forward, as we have actual cases that are adjudicated and denied. So I will keep you up to date on that. And the last thing for this Monday morning is TPS for South Sudan has been terminated, and they are having a 60-day transition period. So that 60-day transition period ends January 5th of 2026, so January 5th of next year. During that transition period, the EADs issued to individuals from South Sudan with TPS will remain valid. So individuals can work through January 5th, 2026. So if you are an employer and an employee, keep that in mind. Start thinking about your plan B. And if you need help with either your plan B for your, if you've got individuals that are on payroll for TPS for South Sudan, or you're not quite sure how your current medical issues will be impacted by your green card application and this new public charge, feel free to reach out to us. We are happy to have a conversation with you about that. And again, I am Carol Williams. This is another Monday morning edition of Beyond the Soundbite. Have a great Monday and a wonderful rest of your week.